incarcerated for criminal trespass without due process. What the launching of Operation Lone Star meant for the Fourth Court of Appeals. I'm Jami Virgin with another edition of Immigration Crisis, the fight for the southern border. Today on the podcast, we're joined by a legal powerhouse who has made a profound impact on Texas law, former Justice Beth Watkins of the Fourth Court of Appeals. She was elected in 2018, and she has authored over 600 opinions and maintained an impressive reversal rate of less than 1%. Before joining the court, she led more than 200 appeals in both state and federal courts, earning board certification in Civil Appellate Law in 2018. So now we're here with Judge Beth Watkins, former judge of the Fourth Court of Appeals. Thank you so much for joining us. And this is a subject that you know a little bit about, Operation Lone Star. Thank you so much for joining us today.
Absolutely, Yami. Thanks so much for having me here to talk about Operation Lone Star and the Fourth Court of Appeals experience with it. You know, in the intro, you said I was a former judge, and for the last 6 years, I was a judge on the Court of Appeals, which covers all of Bexar County and all of 31 other counties in South and Central Texas. And this is the court that hears appeals from all of the trial courts in those counties: civil court, criminal court, family law, oil and gas, you name it. Those appeals go to the Fourth Court of Appeals. And a lot of the Fourth Court's region covers counties that touch the U.S.-Mexico border. And so when you are talking about appeals from those counties and Operation Lone Star, those appeals would come to the Fourth Court of Appeals, where I worked for the last 6 years.
So talk to us about Operation Lone Star. What really was Operation Lone Star? This isn't what you guys normally would do. So you had to learn what it was quickly.
Absolutely. So in March of 2021, remember, this is just 1 year into the pandemic, Governor Greg Abbott signed a series of executive orders that started Operation Lone Star. It's basically orders that deploy state resources in terms of DPS troopers, Texas National Guardsmen and women, armored vehicles, all kinds of different resources down to the border amidst a perceived influx in migration from Mexico and from other countries in South and Central America. Folks that were crossing the border not at legal checkpoints, and the governor decided to kind of unilaterally put a stop to that. Historically, and under the U.S. Constitution, the federal government has the exclusive authority to determine immigration policy for the United States. That's not something that individual states can do. So Texas can't pass immigration law that's maybe different than California's immigration law or New Mexico's immigration law. There's what's called the Supremacy Clause of the U.S. Constitution that says that the U.S. Constitution is the supreme law of the land, and the Constitution of the United States says the feds get the exclusive right to do immigration law. So there's an open question about whether the governor had this authority, continues to have this authority. But to get back to your original question, in March of 2021, the governor signed these series of executive orders to deploy resources down to the border. The idea is, according to the press conference that the governor had at the time, to staunch the flow of illegal, unauthorized immigration into the United States. And they did that basically by militarizing the border. I don't know if y'all remember at the time, but I remember seeing all of these images of razor wire across the border, of buoys down the Rio Grande River. There were terrible stories in the news about people trying to swim across and drowning, children drowning, families being arrested, families being turned back. I remember seeing images of National Guards troops that looked like military operatives in camouflage, wearing, flak jackets and bulletproof vests and helmets and carrying big guns, patrolling the border. And this was all part of that Operation Lone Star process that was designed to kind of reduce immigration into the state of Texas.
So at what point did these cases come knocking at your door and at the court's doors?
Right? So what you had is Texas National Guardsmen and women. You had DPS troopers. And what they were doing is finding folks who had crossed the border, not at lawful checkpoints, and they were either arresting them or turning them around. Sometimes they were calling immigration and having the federal authorities come and take these folks. But in general, what would happen is if somebody was found to have crossed the border unlawfully, they were arrested for criminal trespass, right? For being in a place that they were not authorized to be. And think about what happens, when you see on TV, on Law and Order, or in the movies or whatever. When someone gets arrested, you see them, sometimes they get handcuffs put on them. They get put in a squad car. They are detained. They are taken to a jail. And those things are what happened to immigrants who crossed the border, not at lawful checkpoints. And they were arrested. But most of them were arrested in counties that didn't have infrastructure to help ensure that as, Texans, as representatives of the government, that the government was complying with the mandates of due process. Due process says after you get arrested, you have a bunch of different rights, including like the right to counsel. You get to make a phone call. You can hire a lawyer. If you can't afford a lawyer, then a lawyer gets to be appointed for you. And all of those rights are described not only when you're arrested and you're Mirandized, but also when you're taken in front of a judge and the judge reads the charges to you and sets a bond amount and that determines what is going to happen to you next. Because after you're arrested, typically you either immediately bond out or you're incarcerated. But kind of like rewind and think about that a little bit. Incarceration is the punishment for after you've been found guilty. It's also kind of a temporary Band-Aid for what happens before you maybe get out on a bond, or if you're not entitled to a bond, what happens. But we have this presumption of innocence, and it says that you're innocent until you're found guilty in a court of law. Well, if the punishment is incarceration, but you're also incarcerated before you're brought to trial, that doesn't make a lot, that's not really consistent with a lot of our principles of due process.
So how long were they sitting in jail?
So what happens after you're arrested for criminal trespass is you're taken, like in general, what happens is you're taken in front of a judge. The judge reads the charges to you and then tells you it's a Class B misdemeanor that you've been charged with, this criminal trespass offense. Class B misdemeanor, your maximum time in jail is 180 days and a fine. But the judge also tells you, here's your bond amount, sets the bond amount. And what happens under the Texas law is you have to be given a bond you can afford if the state isn't ready for trial within 15 days. The most for a Class B misdemeanor, like criminal trespass, the most time you're supposed to be able to be held in jail without being given a bond you can afford is 15 days. And what happened right after Operation Lone Star started is they arrested more people than they had jail cells for. They arrested more people than they had ability to get in front of a judge, to give them a magistration, to read them their rights, to appoint counsel for them. And so what happened is a lot of these men, and at this time they were exclusively men that were being arrested, were housed essentially in warehouses. And they didn't have the ability to be brought in front of a judge, to be given a bond that they could afford, to be told that they had the right to appointed counsel. The state just didn't have any of that infrastructure in place. And so they were just sitting in warehouses. And that presented a tremendous, tremendous problem for the state of Texas.
So let me ask you, for the people that say, they entered the country illegally, so why should they have the same rights that a U.S. citizen or a U.S. resident, someone here, legally has?
Because that's what the Constitution of the United States requires. The U.S. Constitution does not differentiate between the rights of citizens and the rights of non-citizens. To me, at least, the Constitution is a statement of kind of what our principles are, what our moral values are. And the framers of our Constitution decided that we were going to treat citizens and non-citizens alike in terms of their interaction with the criminal justice process. So even though they may not have crossed, and the folks that we're going to talk about today may not have crossed into this country legally, the Constitution is about who we are as Americans and how we treat the people that we interact with.
So what was the first case that you got? Which one got all of this going?
So right when Operation Lone Star started, and all of these predominantly men, again, were arrested and were warehoused. There was a huge case that came to our court. It happened in December of 2021. I remember getting the call about it. I was driving to Dallas to spend some time with my family, and I pulled over to the side of the road and was like, oh my God, I have to turn around because I have to go back and sit down at a computer and deal with these cases. What happened in this case, it's called Ex parte Cifuentes. And one of the counties could opt in to Operation Lone Star. One of the counties that opted in to Operation Lone Star is Kinney County. We're going to talk a little bit more about Kinney County here in a bit. But what happened in Kinney County is they arrested a tremendous number of folks who had crossed unlawfully into the country. They charged them with criminal trespass. They sent them to these warehouses, and then there just weren't judges there to bring them before, to magistrate them, to be told what their rights were, to be told that if they couldn't afford a lawyer, they would be given a lawyer, right? They could get a court-appointed counsel. And so what happened is criminal trespass charges, again, the maximum incarceration period is 180 days. And some of these men had been incarcerated for like more than half of the time that they could be sentenced to, but they still were subject to the presumption of innocence that we were talking about earlier, right? So they weren't getting the process that the U.S. Constitution requires. So Texas Rio Grande Legal Aid stepped in and volunteered to represent a bunch of men who had been charged in these cases. And they filed what's called a habeas corpus application. Habeas corpus is described in the U.S. Constitution. It's a Latin phrase, and it translates to bring the body forward. And basically what it is, it's the procedural remedy that you use to say, I am being illegally incarcerated. I'm being illegally detained. I need to be brought in front of a judge, and a judge needs to decide whether my incarceration is legal. And so what happened is Legal Aid filed a habeas application on behalf of hundreds and hundreds of these defendants in Kinney County who had not received due process yet. And the trial court, after a lot of wrangling, the trial court denied that application. Well, then you get to take an appeal of that ruling, and that comes to the Fourth Court of Appeals, where I sit because because we had appellate jurisdiction over all cases from Kinney County. And so in December of 2021, this case landed on our docket. We had to try and figure out what in the world do we do, because there had never been anything like Operation Lone Star before. It was almost like the government of the state of Texas tried to build an airplane while it was already in flight. All of the procedural due process requirements of the U.S. and state constitution weren't in place yet. And that was the subject of this habeas application that was filed right before Christmas 2021 with the Fourth Court of Appeals. And what happened in that case is, these defendants said, let us out of jail. You're holding us illegally. You're not allowed to keep us more than 15 days without offering us a bond that we can afford. And you, state of Texas, haven't done that yet. So at this point, all of these defendants had been found to be indigent. And what that means is they can't afford to pay their own lawyer. That means they get a court-appointed lawyer. They had been held in custody in Kinney County from between 76 to 107 days. And the state was not ready for trial yet. But there's a provision in the Texas Code of Criminal Procedure that says for Class B misdemeanors like this was, the state has to be ready for trial within 15 days of the date that you're detained. And if the state isn't ready for trial within 15 days, then the defendants are entitled to get out on a bond. The trial court either has to give them a PR bond, a personal recognizance bond, like they get out on their own signature, or the trial court judge has to give them a bond that they can afford. That has to happen within 15 days. And some of these guys had already been incarcerated for 107 days, when the maximum punishment that they could get was incarceration for 180 days. So they were being incarcerated and deprived of the benefits that the Texas and federal constitutions provide, the guarantee of a presumption of innocence. They were being treated like they were already guilty, even though they hadn't been brought to trial yet. So the state agreed. It was not ready for trial within 15 days. And so there was a hearing on the application for writ of habeas corpus that these defendants filed. And the defendants argued, hey, we're entitled to be let out of jail on a PR bond or on a bond that we can afford. The trial court judge disagreed and denied their habeas application, did not set a bond in an amount that they could pay, did not let them out on a PR bond.
On what grounds?
Just denied it, and in a plain vanilla order that didn't give reasons why, just said denied. And so we were trying to figure out what in the world, what is the right thing for us to do at this process, right? So we ordered the parties to file briefing really fast in our court. Usually appeals take a long time, but we didn't have a long time. The due process clock was ticking, and we were of the belief that the state was depriving these men of their due process rights every single day that was going by. So we pulled the trigger on a really short fuse. We issued an opinion faster than I have ever seen a court of appeals issue an opinion before, and said the state was not ready within 15 days to go to trial. It admitted it wasn't ready. And that meant the defendants were entitled to a mandatory remedy, either a PR bond or a bond that they could afford. So we said, hey, state, what you have done is deprive these defendants of their due process rights. And so we reversed the trial court's decision to deny the habeas application and sent the case back to the trial court with instructions to very quickly issue bonds in an amount that they could afford or release these men on PR bonds. But something else was going on during this time, even though it was going as fast as it could possibly go in the Court of Appeals. Something else was going on in the trial court while we were trying to get records and determine if we had jurisdiction and do the legal research to figure out what the right answer was. The whole time we were doing that, and it was about 6 weeks, the state was entering into plea bargain agreements with these individual defendants. So when the case was filed in our court, there were 144 defendants. Ultimately, that number ballooned to 153 defendants. But while we were doing everything we had to do to decide the case, the state was entering into plea bargain agreements with these defendants. And think about it. If you have been in jail for 100 days and you're not making money for your family, you're not able to do anything to support your people, even to communicate with your loved ones, to tell them you're alive, you're safe. So what happened is the overwhelming majority of these men entered into plea bargain agreements with the state. And one of the terms of a general plea bargain agreement is if you're a foreign national, you lose your right to immigrate lawfully into the United States. So what happened is most of these gentlemen signed plea bargain agreements to get out of jail. And then as soon as they were released, they weren't just released from the jail cells, the facilities where they were being detained. They were immediately turned over to immigration, who then immediately deported them. But it was the Fourth Court's first experience with Operation Lone Star, and it felt like we had been shot out of a cannon because we were trying to ensure all of the protections of due process for all of these people were being afforded to them, regardless of their lawful immigration status.
So we're going to stop here for this week, but next week's podcast, you had one county that above all others was the squeaky wheel.
We talked a little bit about Kinney County earlier. This case that I just told you about, Ex parte Cifuentes, that case came from Kinney County, and I'm going to show you some information about Kinney County and all of its efforts during Operation Lone Star, and how that ballooned the appeals to the Fourth Court of Appeals for basically the last 3 years.
Friends, that is all for this week's episode of Immigration Crisis, the fight for the southern border. We will be back out in the Del Rio, Eagle Pass, Rio Grande, and El Paso area with all of our colleagues the night before President Trump takes his oath of office to see exactly if there are any changes that take place immediately after he is sworn in. From San Antonio, Texas, I am Jami Virgen. Have a wonderful new year, and we will be right there with you, reporting from the southern border.